the official statements of the United States authorities themselves, Iran, its nationalists, and its companies are the target of what the respondent describes as third country measures, as well as of measures aimed directly against the Iranian entities, and of those against U.S. persons which are intended to prohibit them from engaging in transactions with Iran, its nationalists, or its companies. However, it cannot be inferred from the above that all the measures at issue are capable of constituting breaches of the United States obligations under the Treaty of Amity. What's decisive in this regard is whether each of the measures or category of measures under consideration is of such a nature as to impair the rights of Iran under the various provisions of the Treaty of Amity, which the applicant claims to have been violated. Conversely, the fact that some of the measures challenged, whether or not they are the vast majority, as the United States maintains, directly target third states or the nationalists or companies of third states, does not suffice for them to be automatically excluded from the ambit of the Treaty of Amity. It's only through a detailed examination of each of the measures in question, of their reach and actual effects, that the court can determine whether they affect the performance of the United States obligations arising out of the provisions of the Treaty of Amity invoked by Iran, taking account of the meaning and scope of those various provisions. In sum, the court considers that the second preliminary objection of the United States relates to the scope of certain obligations relied upon by the applicant in the present case and raises legal and factual questions which are properly a matter for the merits. If the case were to proceed to the merits, such matters would be decided by the court at that stage on the basis of the arguments advanced by the parties. In light of the foregoing, the court finds that the second preliminary objection to jurisdiction raised by the United States cannot be upheld. For all the reasons set out above, the court finds that it has jurisdiction ratione materia to entertain the application of Iran on the basis of Article 21, Paragraph 2 of the 1955 Treaty of Amity. The court now turns to the question of the admissibility of Iran's application. The objection to admissibility raised by the United States is based on the contention that, and I quote, Iran's claims amounted to an abuse of process and would work an injustice that would raise serious questions of judicial propriety, end of quote. This is because, according to the United States, Iran has invoked the Treaty of Amity in a case involving a dispute that solely concerns the application of the JCPOA. The court noticed that the United States did not address its objection to the admissibility of Iran's application during the oral hearings, but expressly maintained that objection. As the court has observed in an earlier case, it's only in exceptional circumstances that it should reject a claim based on a valid title of jurisdiction on the ground of abuse of process. The court has specified that there has to be clear evidence that the applicant's conduct amounts to an abuse of process. In the present case, the court has already ascertained that the dispute submitted by the applicant concerns alleged breaches of obligations under the Treaty of Amity and not the JCPOA. The court has also found that the compromissory clause included in the Treaty of Amity provides a valid basis for its jurisdiction with regard to the applicant's claims. In the view of the court, there are no exceptional circumstances that would justify considering Iran's application inadmissible on the ground of abuse of process. The fact that Iran only challenged the consistency with the Treaty of Amity of the measures that had been lifted in conjunction with the JCPOA and then reinstated in May 2018 without discussing other measures affecting Iran and its nationals or companies may reflect a policy decision. However, as was noted in an earlier case, the court's judgment cannot concern itself with the political motivation which may lead a state at a particular time or in particular circumstances to choose judicial settlement. In any event, the fact that most of Iran's claims concern measures that had been lifted in conjunction with the JCPOA and were later reinstated does not indicate that the submission of these claims constitutes an abuse of process. In light of the foregoing, the court finds that the objection to admissibility of the application raised by the United States must be rejected. The court now addresses the objections raised by the United States on the basis of Article 20, paragraph 1b and d of the Treaty of Amity. Article 20, subparagraph 1b provides that the Treaty of Amity shall not preclude the application of measures relating to fissionable materials, the radioactive byproducts thereof, or the sources thereof. For its part, subparagraph 1d provides that the treaty shall not preclude the application of measures necessary for the protection of the essential security interests of a high contracting party. The court recalls that in the oil platforms case, Islamic Republic of Iran versus United States of America, it found that, and I quote, Article 20, paragraph 1d of the Treaty of Amity does not restrict its jurisdiction in the present case, but is confined to affording the parties a possible defense on the merits, end of quote. A similar view was expressed in the case concerning certain Iranian assets, where the court noted that the interpretation given to Article 20, paragraph 1 with regard to subparagraph D also applies to subparagraph C, which concerns measures, and I quote, regulating the production of or traffic in arms, ammunition, and implements of war, end of quote. The court observed that there were no relevant grounds on which to distinguish subparagraph C from subparagraph D. The court finds that there are equally no relevant grounds for a distinction with regard to subparagraph B, which may only afford a possible defense on the merits. The parties do not dispute that arguments based on Article 20 of the Treaty of Amity do not affect either the court's jurisdiction or the admissibility of the application. However, the respondent argues that objections formulated on the basis of Article 20, paragraph 1b and d may be presented as preliminary according to Article 79 of the Rules of Court as, and I quote, other objections, the decision upon which is requested before any further proceedings on the merits, end of quote. The applicant contends that subparagraph B, which refers to measures relating to fissionable materials, should be interpreted as addressing only measures such as those specifically concerning the exportation or importation of fissionable material. It was, however, argued by the respondent that subparagraph B applies to all measures of whatever content addressing Iran's nuclear program because they may all be said to relate to the use of fissionable material. The question of the meaning to be given to subparagraph B and that of its implications for the present case do not have a preliminary character and will have to be examined as part of the merits. A decision concerning these matters requires an analysis of issues of law and fact that should be left to the stage of the examination of merit. The same applies to measures taken by the United States, allegedly because they are deemed necessary to protect its essential security interests and are therefore argued to be comprised in the category of measures that are outlined in subparagraph G. The analysis of this objection would raise the question of the existence of such essential security interests and may require an assessment of the reasonableness and necessity of the measures insofar as they affect the obligations under the Treaty of Amity. Such an assessment can be conducted only at the stage of the examination of the merits. For the foregoing reasons, the Court concludes that the argument is raised by the respondent with regard to Article 20, paragraph 1b and d of the Treaty of Amity cannot provide a basis for preliminary objections, but may be presented at the merits stage. Therefore, the preliminary objections raised by the United States based on these provisions must be rejected. I shall now read out paragraph 114, the operative part of the judgment. For these reasons, the Court, 1, unanimously rejects the preliminary objection to its jurisdiction raised by the United States of America, according to which the subject matter of the dispute does not relate to the interpretation or application of the Treaty of Amity, Economic Relations and Consular Rights of 1955. 2, unanimously rejects the preliminary objection to its jurisdiction raised by the United States of America relating to the measures concerning trade or transactions between the Islamic Republic of Iran or Iranian nationals and companies and third countries or their nationals and companies. 3, by 15 votes to 1, rejects the preliminary objection to the admissibility of the application raised by the United States of America. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham Benuna, Cansado Trindade, Gaia, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge Ad hoc Mumtaz. Against, Judge Ad hoc Prawa. 4, by 15 votes to 1, rejects the preliminary objection raised by the United States of America on the basis of Article 20, paragraph 1b of the Treaty of Amity, Economic Relations and Consular Rights of 1955. In favor, President Yusuf, Vice President Shue, Judges Tomka, Abraham Benuna, Cansado Trindade, Gaia, Sebutinde, Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge Ad hoc Mumtaz. Against, Judge Ad hoc Prawa. 5, unanimously rejects the preliminary objection raised by the United States of America on the basis of Article 20, paragraph 1d of the Treaty of Amity, Economic Relations and Consular Rights of 1955. 6, by 15 votes to 1, finds consequently, that it has jurisdiction on the basis of Article 21, Paragraph 2 of the Treaty of Amity, Economic Relations and Consular Rights of 1955, to entertain the application filed by the Islamic Republic of Iran on 16 July 2018, and that the said application is admissible. In favor, President Yusuf, Vice President Shue, Judges Tomka Abraham Benuna Cansado Trindade, Gaia Sebutinde Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, Judge Ad hoc Mumtaz. Against, Judge Ad hoc Prawa. I shall now call upon the registrar to read the operative part of the judgment in French.
Merci, Monsieur le Président. Par ces motifs, la Cour, 1, à l'unanimité, rejette l'exception préliminaire d'incompétence soulevée par les États-Unis d'Amérique, selon laquelle l'objet du différend ne concerne pas l'interprétation ou l'application du traité d'amitié, de commerce et de droit consulaire de 1955. 2. À l'unanimité, rejette l'exception préliminaire d'incompétence soulevée par les États-Unis d'Amérique relative aux mesures qui concernent le commerce ou les transactions entre la République islamique d'Iran ou ses ressortissants et sociétés et des pays tiers ou leurs ressortissants et sociétés. 3. Par 15 voix contre 1, rejette l'exception préliminaire d'irrecevabilité de la requête soulevée par les États-Unis d'Amérique pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc. Contre, M. Brower, juge ad hoc. 4. Par 15 voix contre 1, rejette l'exception préliminaire soulevée par les États-Unis d'Amérique sur le fondement de l'alinéa B du paragraphe 1 de l'article 20 du traité d'amitié, de commerce et de droit consulaire de 1955. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc, contre M. Brower, juge ad hoc. 5. À l'unanimité, rejette l'exception préliminaire soulevée par les États-Unis d'Amérique sur le fondement de l'alinéa D du paragraphe 1er de l'article 20 du traité d'amitié, de commerce et de droit consulaire de 1955. 6. Par 15 voix contre 1, dit en conséquence qu'elle a compétence en vertu du paragraphe 2 de l'article 21 du traité d'amitié, de commerce et de droit consulaire de 1955 pour connaître de la requête introduite par la République islamique d'Iran le 16 juillet 2018 et que la dite requête est recevable. Pour M. Youssouf, président, Mme Choué, vice-présidente, M. Tomka Abraham Benuna Cansado Trindade, Gaïa, Mme Sebutinde, M. Bandari, Robinson, Crawford, Gevorgian, Salam, Iwasawa, juge, M. Montaz, juge ad hoc, contre M. Brower, juge ad hoc.
I thank the registrar. Judge Tomka appends a declaration to the judgment of the court. Judge Ad hoc Brower appends a separate, partly concurring and partly dissenting opinion to the judgment of the court. The text of the judgment is available from today in TypeScript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no further business before it today, I declare the sitting closed.